All right. So now that everyone's here, I think we're good to get started.
Right.
Good morning, everyone. Today is Tuesday, June 11th, 2024. The time is 9:32 a.m. and this is a status conference in the matter of Robert Devine, case number 2024-004-S before the Massachusetts Peace Officer Standards and Training Commission. This is a public proceeding and proper notice has been provided. We are convening remotely via Zoom and this conference is being recorded. The Honorable Kenneth J. Fishman will be the presiding officer over this pre-hearing conference today, and my name is Lizzie, and I'm the hearings administrator for the Post Commission. This matter is now before Judge Fishman.
So good morning again. Counsel, if you just state your appearances, please.
Sean Martinez for the Division of Standards.
Good morning.
Robert Stowe for Robert Devine, who is present with us.
Good morning, Mr. Devine. At our last pre-hearing conference, we scheduled this status conference. I guess that was actually back in March, primarily because there were discovery issues outstanding. And I guess, Mr. Martinez, can you bring me up to date on where that stands now?
Yes, Your Honor. So I have turned over all the discovery. It took us a couple weeks actually because the files were not formatting correctly, so Mr. Stowe could not access them. However, he did come to our office. I believe it was approximately 3 weeks after the conference, and we did get everything up and in order. So approximately 2 to 3 weeks after, we made sure all the files were correct, but I had turned over the discovery virtually a few days after the conference and then on a physical hard drive a week after the conference.
So I know that there had been a proposed protective order, which I was going to approve. Did I ever sign off on that, or were you?
Yes, you did.
Okay. See, you get to a certain age, you don't remember these things. So, I also know we took a look at the docket on the civil case, and I know there was a more substantial, if you will, protective order dealing with that information, and there were a number of redacted documents and the like. What's the status of that? Has that been inaccessible to the parties?
There is a protective order in place. I was talking to Mr. Martinez yesterday about this. It's a narrower protective order than we have here. Okay. The town of Stoughton has released, and I received on Saturday, but I haven't opened it yet, the 1 terabyte hard drive, which is referenced in or are 2 exhibits that are part of the report that Your Honor has allowed us to have and allowed my client to look at, the unredacted report. They tell me that 1 terabyte is the equivalent, excuse me, of 250 2-hour movies as far as data goes.
Wow.
When someone says to me 1 terabyte, it kind of means nothing. It's like the distance between, the planet and the sun.
Yeah.
But it seems to be a crazy substantial amount of information. I'm sure there are going to be ways that I can go through it much more quickly, but I don't know what's there, and I can't give it to Attorney Martinez because there's a protective order from that court. From the Norfolk Superior Court. So I'm kind of in this pickle where I have access to this information. Attorney Martinez doesn't. I'm still going through a little bit. I think I've pretty much gone through everything we have from our case. You have a couple more hours, I think, to go through that, but I think there's probably be some overlap. But then it's the 1 terabyte hard drive I have to tackle, and I have no idea what's in there.
So just so the record is very clear, we all know it, but I want the record to be clear. What we're talking about is the civil action in Superior Court. Just looking for the caption on it, in which Mr. Devine is a defendant, and it's civil action 22-1197. It's in Norfolk Superior Court. And I know that the presiding judge, maybe Judge Davis, if I remember correctly, had whoever it was, had issued a protective order. You finally got the information consistent with his orders and the protective order I'm hearing. Right. Apparently it's a massive material that you have yet had. You just got it. and you've yet had an opportunity to review it. Is that fair to say?
That is correct. I got it on Saturday and today is Tuesday.
And as a result, even though you get access to it as a party in the civil action, enforcement counsel would not, unless we're able to arrange for it, and it's material you anticipate trying to use or introduce in the course of a hearing on the matter before the post commission. We'd have to figure out a way for enforcement counsel to get to see it as well, obviously.
I agree.
But it sounds like, well, and I was going to say, it doesn't necessarily simply depend on whether it's material that you intend to use. It might be material that even if you don't intend to use it, enforcement counsel may want to use it as well. Have you folks talked about that?
We haven't. I spoke with Mr. Martinez yesterday briefly and told him what I had as far as information goes, and that I got it. We haven't talked about the use of it as evidence at all. As I said, I haven't looked at it. I understand. I can tell Your Honor what was disclosed in public record in the courthouse, what it contains. Apparently, it's a computer dump of the person's computer. So we don't know what's on there. I do know from the public discussion, I guess the chief of police had that she disclosed that there were relationships that the decedent had with Army recruiters or recruiters. There could be many more persons involved that other than my client and the Farrell brothers, I guess. So we don't know what's in there, and I suspect, having viewed some of the evidence in our case that you are allowed to disclose to me, that there may be lots of other, I'll just want to disclose what it is. There may be lots of other video that we haven't seen, that no one's seen. So,
by the way, has the, just as a sideline, has the civil case resolved as to any of the defendants, or is it just...
we're still doing discovery. I'm in the process. One of the things that was holding up discovery was this particular 1 terabyte of information, and my client wasn't even able to see the full report until Your Honor was allowed to see it. So the Superior Court case has been slower than us in getting discovery to my client to pursue the case. So that's been one of the problems.
Yeah. Well, Mr. Martinez, what are you thinking about how the you want to proceed?
Yes, I will say that I anticipate much of the discovery will be the same for both this case and the civil case. I expect there to be a large amount of overlap. A lot of what I did turn over to Mr. Stowe was materials obtained through that computer dump, which also within that contain backups of cell phone information. With that said, I know that there are several years of messages contained. There's several years of photographs, videos. It is voluminous. From my perspective, we've turned over our entire file. We're not withholding anything. We're not saying anything is irrelevant. Pursuant to the protective order, we turned over everything to Mr. Stowe. So if there's sort of a large amount of materials that we don't have, for example, once Mr. Stowe reviews, if there is a large amount of materials that the division didn't have, I think that Mr. Stowe and I can work towards, problem solve towards a way that we can work with the Stoughton attorneys if there's material that could be relevant to this case. Mr. Stowe and I have been working well together thus far in this case, and I don't expect that to change. So I do believe it would be appropriate to give Mr. Stowe some time to review the 2 discoveries and see if there are discrepancies, and if there are, we can work towards a way to ensure that enforcement counsel also has access to the additional materials. Whether that be me contacting the town directly or making the division a party to a protective order as well. I do feel that would be appropriate.
I agree that we need more time, and I will say that when I met with Mr. Martinez, he was very straightforward. But
I think the judge may have frozen. I think he might have disconnected.
Yes, sorry, give me one moment.
No problem.
Now we can. Can you hear me, Lizzie?
Yes.
Okay.
Yeah.
It was very interesting to see all of you frozen. I figured it's because of a lousy joke I made in a serious matter that caused it to freeze. But as a practical matter, do you have a sense? I know it sounds like a lot of material to look through, and much of it may be material that you haven't seen through the discovery in this matter. Mr. Stowe, so what are you proposing for a time period to go through it, to work together, to resolve, to make sure that both sides have access to the available material out there? Have you thought about that?
that's kind of a two-part question. One is both sides having access. I can't disclose the information I received in the Norfolk Superior Court case. The
Right.
protective order prevents me from doing that to anyone except.
No, and we may need to engage in a process to make that happen. I get that. But let's start with your review and we'll work from there.
I suggest that a 2-month period of time. I know that the one of the Farrell cases was moved out for, I believe, 6 or 7 weeks. If we track, that's what I talked to Mr. Martinez with you about yesterday.
Yes, the next conference on that matter is August 6th. And that on the related Farwell matter is August 6th, and the conference was actually last week on June 4th. So the 2-month period would keep the cases generally on a similar track.
Okay.
That's what I'm thinking.
All right. Now, in the interim, if you realize that they were going to have to go through a process to make things happen, to the extent you're, even whether you're agreed on it or not, we don't need to wait 2 months. I mean, I will set it up for a further conference in 2 months, but I would suggest that if there's process that needs to happen to move the case forward, you ought to get in touch with the Lizzie, and if you think it's appropriate to file something at that point, then we'll have a chance to look at it. But I'll certainly 2 months does not seem unreasonable given what I'm hearing here today.
It might be too short.
No, I understand that. I have every faith in you, Mr. Stowe.
It's going to be a lot of time.
Yeah, of course. But in all fairness, you may see, for all you know, there's lots that isn't particularly relevant for your consideration. So, but you need to look at it. So let's, why don't we set up a date? Liz, you want to propose something 2 months out?
Sure. So just looking at the calendar, about 2 months out would be, August 13th, or August 20th. Do either dates work for both parties?
13th, I have a doctor's appointment for an elderly gentleman I'm caring for. So August 20th would be better.
Okay.
That works for me as well.
Yeah.
Okay, so how about Tuesday, August 20th at 9:30 a.m.?
That works for me. Does that work for you, Mr. Devine?
Yes, sir, it does.
Thank you.
All right. And for me as well. So we'll schedule it then. Again, don't feel that if you need our intervention or any rulings out of this commission, then just get in touch with us ahead of time.
Thank you.
Is there anything else we need to discuss at this point?
I don't believe so, not from the division's perspective.
I don't believe so either.
All right. We're all set. We'll see. Next meet on August 20th at 9:30 a.m.
Thank you.
Thank you.
Thanks.